The 17-year-old who killed both of his parents is now a free young man. He was released from jail last night. Court TV on the ground in Florida when Colin Griffith was picked up by, you guessed it, Grandma Susan and one of his aunts. There he is. Those ladies did not want to be on camera. Colin acquitted of murder earlier in the day. Let's look back at the shocking verdict.
State of Florida versus Colin Griffith. We, the jury, find as follows. As to the defendant in this case, the defendant, as to count one, the defendant is not guilty. As to count two, the defendant is not guilty. So say we all, this 5th day of February, 2025.
I guess he's got a lot of love for those lawyers there. Let's talk about what's next for this young man. So he's living with Grandma Susan, and we know that the prosecution built its case on the reason Mom was murdered, they said, was because she was ready to expose him for murdering his father. She had incriminating messages that indicated that he had bad intent when his dad was killed. And we know that case was ruled a self-defense case, and he ultimately wasn't put through the system. So what happens in Oklahoma now? Are investigators going to take a second look at this? Are they going to look at Mom Kathy's messages and what she discovered about her son and perhaps charge him? Let's talk about it. I want to bring back in Michael J. Brown and John Phillips. Michael, you first, please, your thoughts.
Wow, in regards to the verdict, Julie, it was pretty remarkable considering the evidence that I think we all knew about. In terms of it affecting the initial case with the father, my initial inclination is absolutely not. Obviously, you can't use this acquittal in any fashion against him. We have to assume that they did a thorough job on the first go-round with the father, and I don't know if any additional information has come forward in regards to the murder of the father. Now, clearly, there was information that led the prosecutor to charge him with the murder of the mother, but I don't know necessarily that any of that would be relevant to the murder of the father. So my inclination, without knowing more, would be no. There's no way that they can. I mean, they certainly can reopen it. It's not as if jeopardy attached, but I don't think there's any new additional information that's going to cause them to say, hey, we have enough and we can prove this case beyond a reasonable doubt.
I see what you're saying, Michael. And a follow-up for you, please. So if, let's just say, Kathy, from the time that investigators in Oklahoma closed that case and said, you know what, we're satisfied it's self-defense, if Kathy discovered new information, like let's say he made admissions or she saw something, and then later, then would that be something they would be interested in and could potentially use?
100%, Julie. So if there's an admission made by the son and he said, you know, what I did to Dad, I beat that case. Look at me. I got away with it. I should have stabbed him 20 times or shot him more. Any admissions that they obtained as a result of this investigation on the instant matter absolutely could be used against them, and that, quite frankly, could push them over the edge.
Right. You know, and speaking of, this is a legitimate concern, as you both know. John Phillips, I want to go to you on this question. He is free. He is walking among us. I mean, everybody in Florida, I would think, in this community where he is, would be just on pins and needles knowing this kid's history. What do you think about the danger that he is right now? Do you think Grandma Susan ought to be worried, John?
You know, based upon reading the kind of summary of her testimony, she seemed a bit naive. But let's be clear, there are no winners here. And what we have in reading through some of the notes of the trial is just such systemic abuse, neglect, where, you know, you had violence and extortion between parent and child. And that's no way to live. And I've got a 13-year-old and a 10-year-old, and I always, you know, my wife and I always talk about how much information and how much danger they have at the tip of their nose. And we see this all too often where kids are kind of radicalized by what they do and see, and then they have parents who are neglectful, and here it was a whole different level. It's just awful. And And I agree with Michael on the point of, and you on the point of, if there are some material statements that he made in text messages, statements against interest, statements of admission, I think it not only opens up the criminal case for the murder or death of the father, but some level of witness tampering. He may have killed a witness to a capital crime, and that itself is a capital felony in most states. So there's a lot more to look at.
Great point. John, thank you for that. I want to ask you both about the judge's ruling, because the judge kind of split the baby here and said, jury, you can know that he killed someone previously in self-defense, but you can't know it's dad. And the state wanted to bring that in as his MO, as a kid who was looking to take out the two people that brought him into the world. Does the judge bear any responsibility here? Michael?
No, I don't, Julie. And I listened to your opening statement. I actually had a problem with the judge's ruling. I understand that it was important to show the motive for why he allegedly killed his mother, because she was going to disclose this act. The fact that they sanitized it by taking out the father was halfway there, but I don't even think they should have gotten out the fact that it was a murder, because he's being, or a homicide, because he's being tried for that very same crime. If that was in New York State, I highly doubt that the judge would permit the introduction of that evidence. They certainly would allow some testimony about, hey, there was some crime and or something happened, and as a result, we were going to disclose it. But I don't think they would ever get into the homicide allegation.
I hear you. We have about 20 seconds, but John Phillips, I want to get your thoughts on that.
I totally agree. The prejudicial effect of that, had there been a conviction, would have led to another appeal. So, here we are, and I just, it's just horrible situation.
Yeah, it really is. I'm sure the judge is sick about it, and trying to do the balancing test. The judge made a thoughtful decision to try to protect his fair trial rights, but also allow in what the rules of evidence provide to be allowed in. There's so much more to say on this case. We're going to keep an eye on Colin Griffith, and we're going to talk more about it. I know I have to let you both go and get off to court. Love having you both on the show. Michael J. Brown, John Phillips, thank you both for everything today. We'll see you soon. And that's all for opening statements, my friends.